What if for some reason Commissioners Court, they can't reach consensus? They can't, we're not gonna canvass the votes, we're not gonna accept them. Can you give them any direction after that? Or what do they do next?
The only thing we can do as an attorney, and I would go for any attorney involved in this case, is to give advice as what they should do. The advice that we're going to give is that they should reach a conclusion based on what they feel are the correct numbers. I don't think anybody would disagree that all legal votes should be counted in an election. I don't think you'll find either side disputing that. So I think what the canvassing authority, this point being the Commissioners Court, has to do is determine which set of the numbers they feel is the correct set of numbers. And a lot of that is going to come from Mr. Ortiz and his staff, and I believe that's why they're presenting affidavits on that. But the canvassing authority, it's like a hearing, so they can question Mr. Ortiz, they can question people involved in this, and they can determine for themselves what are the true numbers. If they don't proceed with ultimately or finally stating who won, then the status quo will remain. The current county judge stays in office until the matter is resolved, and the matter will have to be resolved in the courts. At that point, one of the sides would then have to take it up on mandamus to force the canvassing authority to make a decision. The only entity, or the only, I don't want to say a person, but the only thing that can force them to make a decision would be the courts. The courts would have ultimate say on this if the canvassing authority does not make a decision. Now, we expect that whatever decision the canvassing authority makes, that the losing side will then issue an election challenge, and so this would wind up in the courts any way you look at it.
Could they order a new election?
The canvassing authority does not have the authority to do that. All they can do is determine what results they're going to certify as true results of the recount. Both parties, though, I have been made aware of, have asked for, have instituted a part of the election code within 48 hours of the recount being completed, which would be Saturday night, more or less between 9 and 10 p.m. Either side can have a chair for a certain precinct enter an affidavit asking that their precinct be recounted again based on discrepancy. And my understanding is that the Democrats have requested a recount of precinct 54 since it's in dispute, and the Republicans, my understanding, have filed affidavits seeking other precincts to be recounted as well. That authority lies solely on Mr. Ortiz, whether or not to honor those requests or just to move forward with what figures he has already and pass it on to the canvassing authority. Once the canvassing authority gets this information, they don't have the power to recount anything. All they can do is, if there's a discrepancy, which we have here, they can ask for people involved in that discrepancy to come forth and give them information about it, and then they can make their decision. Decided to make any further recounts on any precincts. He has not indicated a reason for that, and he has not sought any advice on that, to my knowledge, and I think that's solely within his discretion.
And how soon were we all called in to start? When did y'all start investigating?
Well, like I said, on Sunday we were called because there was rumors of possible fraud, possible hiding of ballots or finding of new ballots. The rumor mill was running wild on Sunday, so we were called by concerned citizens, and we were called, the Texas Rangers, I'm not sure how they received knowledge of this, but we were called by them directly. But everything that I have seen and the interviews that we've had with Mr. Ortiz, this is not an issue involving fraud or finding of votes or missing votes. He's indicated to us that this is an issue tantamount to a clerical mistake. That's not to say in the future that somebody couldn't come forward and say, well, we saw something else going on. But we are not privy to any information at this point that there's any allegations of criminal wrongdoing. We have been told more than once that the issue is a clerical error, and how do you correct that clerical error?
Well, what, do you think somebody should be held accountable for that clerical error?
Well,
I mean, considering look how many days we still don't know who the winner is. I mean,
there is a lot of frustration. There's major frustration in the community, and the other elected officials that I've come in contact with, and the community members I've come in contact with, are extremely disappointed in the manner that this has gone about, because we're 2010, and we are a couple of weeks past the election date, and we still don't know who our county judge is officially. I don't think there's anything we can do to change that at this point, except to wait for Friday. 5 o'clock, I believe, is the Commissioners Court meeting, and at that point, I would hope that the issue would be resolved so that we know at least who the county judge is, pending court action or inaction.
So to be clear, on Friday, Commissioners Court should be able to determine who won the election.
That's correct.
If they accept the canvas, the votes.
It'll be their decision to decide which set of votes to accept and to officially proclaim as the votes for this election.
And if they don't accept them, Judge Coscos will remain, I guess, as judge-elect or whatever until it goes to the courts and everything is resolved in the court system.
If the Commissioners Court does not make any determination, if for some reason only 4 show up, or
well technically,
one can abstain, even if both Coscos and Wood abstain, you still have 3 commissioners. Right. If another commissioner would abstain, and then you'd have a 1-1. In that scenario, if things would stay status quo until a court decided. If they declare Coscos the winner and John Wood sues, Coscos would stay the winner, take office until the court is resolved, one way or the other. If they declare Wood the winner and Coscos sues, Wood would stay the county judge until the court decides otherwise. So there still will be a county judge. 2 of the scenarios would be Coscos, 1 scenario would be Wood, but we will still have a county judge, and I almost guarantee that there will be a court battle.
So then basically, I mean, bottom line is the county judge is going to be decided by the courts.
Unless one of the candidates decides that it's not in the best interest of the county to go through this, and so to speak, throws in the towel, or decides that it's best to reconcile this situation and move on. If that would occur, then the courts will not decide it. Absent that, I think you're correct. At some point, the courts are going to have to weigh in on it.
Do you know how much such a case would cost the county if it went through the court system?
It is going to be, I would assume, rather expensive, because it will not end, in my opinion, at the trial level. Whatever the trial court decides, I would suspect that it's going to be appealed, go to the appellate courts, and then whatever the appellate courts decide, I would assume that the losing party will then try to get the Supreme Court to weigh in on it. This really is an issue that we've looked and looked and looked, and there doesn't seem to be any case law on it. It's, like I said, most people are claiming it's a clerical error, and most clerical errors are corrected by common sense. So we would hope the Commissioners Court would just view this and determine it, and that the 2 candidates would get together and abide by whatever decision the Commissioners Court makes and move on.
When you say expensive, do you have any dollar figures?
Well, I mean, anytime you involve attorneys and you involve trials, and you're paying them by the hour, I mean, it could easily exceed a couple of $100,000 easily.
And who would pay? Would it be the taxpayers that would have to fund this?
Well, the candidate who loses would have to fund their own attorney, but the lawsuit would be against the elections department. In this case, the elections department would be defended by the county. So yes, ultimately the county would pay for the defense. Now, they could hire outside counsel, they could use a Commissioners Court counsel, they could ask us to defend them, so it's hard to say exactly who would do the defending until we reach that stage.
And at precinct 54, how many votes were there? And do you know those figures as far as how many there were?
I don't have the exact figures on me, but it was several hundred votes. Precinct 54 is Burns Elementary, which is one of the largest precincts in the county, and it routinely, in elections past, has close to 1,000 votes. So I mean, we're talking quite a number of votes that are in that precinct, and ordinarily, when you review the tallies, if you're experienced in that, you would see if the amount here was, say, 300 or 400, that should be a tip-off that those numbers don't seem correct, because Burns Elementary, I mean, routinely the polls close at 7, and in Burns the lines still snake out of the school there, and so that is a high turnout precinct, and normally the numbers reach almost 1,000 in that precinct.